Are they or are they not your client yet? When and how should you pose the question? It's advisable not to inquire immediately, but before extending your services to the buyer, you should ascertain if they are currently bound by any exclusive buyer-broker agreement. A simple inquiry about whether they are working with another realtor is insufficient, as working with a realtor under the Reed form differs from being bound by an exclusive agreement under the BBEA form. A better idea would be to ask if they have signed a buyer-broker, Reed for, or anything else in writing that ties them to another agent. The buyer may not readily grasp the question, given that so few agents have requested their buyers to sign the BBEA in the past. Now it is a required disclosure and agreement for employment between the buyer and the agent. Nevertheless, it is crucial to ask, and your subsequent actions will hinge on the buyer's response, which will likely fall into one of the following categories. Yes, we signed a buyer-broker agreement with Agent Jones. No, several agents asked us, but we have not signed any buyer-broker agreements. What are you talking about? What do you do if the buyer responds with a yes? In this case, you are obligated to assist them, but must direct them back to their agent for any contract-related matters. I would not help in any way that implies agency. If a buyer expresses dissatisfaction with their current agent, indicates a lack of trust, or states that their agreement has been canceled, you may consider working with them. However, before proceeding, it is critical to have your buyer provide you with a written disclosure that they may still be contractually obligated to pay their former agent a commission if they purchase a property through you. There are instances where the previous agent may have shown a property in the past under their buyer-broker agreement. The buyers may have to pay 2 commissions: educate and protect your client. To protect all parties and avoid potential disputes, the buyer should formally terminate their relationship with the previous agent in writing. Additionally, you should obtain written confirmation that the former agent will not be entitled to compensation before you begin working with the buyer. While this conversation might be challenging, it is necessary if the buyer discloses a signed agreement. If the response is no, or a lack of understanding, and after explaining the concept, you are confident that the buyer has not signed an agreement, feel free to proceed with working with them. In accordance with Arizona Revised Statutes, ARS 322153A2, the Real Estate Commissioner holds the authority to take various actions, such as suspending or revoking a license, denying license issuance, issuing letters of concern, providing provisional licenses, or refusing license renewal. This authority is exercised if it is found that the license holder or applicant, within the immediate 5 years preceding the action, has engaged in acts, authorized by the license or the relevant chapter, involving representing more than one party in a transaction without the knowledge or consent of all parties involved. Similarly, Commissioner's rules, specifically R428-1101F, state that a salesperson or broker is prohibited from accepting compensation or representing more than one party in a transaction without the prior written consent of all parties concerned. Consider a scenario where you begin working with a buyer, having them sign both the Reed form and the BBEA, indicating a $10,000 commission. While explaining to the buyer that you used to receive the commission from the listing broker, there might be instances where they need to cover some or all of it. It is very important that the buyer understands and agrees to potentially be responsible for part or all of the commission. Upon selling them a house, the listing agent will pay you $8,000, even though your BBEA states $10,000. The buyer, in agreement, will pay you $2,000 at closing. While the buyer has given prior consent through the BBEA, the seller has not. Thus, the disclosure of receiving compensation from both parties should be included on the BBEA, considering R428-1101-F's requirement for prior written consent. F. A salesperson or broker shall not accept compensation from or represent more than one party to a transaction without the prior written consent of all parties. Prior consent would be necessary if the buyer and seller are working with agents who have the same broker. receiving a commission from more than one party would be the listing agent working with the buyers, or a broker who receives both sides due to dual agency that has two different agents. While looking through the MLS for listings, we'll not see co-broke offers of any kind. Is it ethical to only show homes with a higher co-broke? Of course not, and that is where the BBEEA comes in also to protect your commission. If the BBEEA states the buyer will pay you A%, then it does not matter what the listing agents are offering to you as a co-broke as long as your buyer understands that they may have to come in with more money to fill the gap. If the listing agent is offering more than what is on your BBEEA, then the buyer will owe you $0 when that transaction closes. How do agents find out now if the seller is offering a co-broke? They call the listing agent and ask. You may get several different answers. Yes, with no other info. Yes, with an amount or percentage of the purchase price. Or you may just get a send in your offer with the seller compensation addendum. All the rules and codes outlined above serve as a roadmap for agents to provide comprehensive agency disclosure. It is evident from these regulations that agents have a clear obligation to ensure their clients are informed about who they represent and the manner in which they are represented. What types of agency are there? Buyer's agent, seller's agent, and dual agency we have already talked about. Special agency. How about considering special agency? In real estate, a special agent is someone hired for a specific duty by a client, with their authority restricted to that particular task. The agency agreement concludes once the assigned job is completed. An example of a special agent is a listing agent engaged to sell a client's home or find a buyer. The relationship terminates upon task fulfillment. Now imagine an agent serving as a general agent for a client. A general agent in real estate possesses the authority to execute any acts associated with the ongoing business delegated by the principal. Property managers often act as general agents. Universal agents. Then, there are universal agents who wield complete authority to perform any actions for a person or business, acting on behalf of the client. Universal agents typically hold power of attorney, representing the broadest and most potent form of agency. Although rare in real estate, universal agency may arise in situations involving elderly parents and their adult children, or when a court appoints someone to manage a client's affairs due to incapacity. Implied agency. Let's delve into implied agency. In real estate, an implied contract isn't written, but stems from a mutual understanding based on the actions of the involved parties. Implied contracts carry legal weight similar to express contracts, but unlike express contracts, there's no need for additional written confirmation. The relationship between a real estate agent and a client defines implied agency, such as a seller's agent working to sell a property without a formal contract. This can be tricky, and the agent may not receive a commission for any services provided to that party. What do I mean by that? Say an agent meets a person on the street waiting for a bus. The person starts to small talk as shares that she is looking for a home to purchase. The agent introduces herself and says that she can help her find a home. The exchange information, and the agent starts to send her properties to preview. The person is not yet the agent's client, as there is no formal written action. Or a neighbor who starts to ask real estate questions to her real estate neighbor on how to list her home. The agent explains the process, and the neighbor has her sister then list the house. The agent had implied agency, but nothing to guarantee a pay outcome. Or, the agent and the new client start moving forward to find a property and end up putting an offer on a home that is accepted without any formal agency written confirmation involved. An agency occurs when a principal and an agent do not expressly create an agency relationship. The agency is implied from the conduct of the parties. The extent of the agent's authority is determined by the particular facts and circumstances of the particular situation. Limited agent. Now, what about a limited agent in real estate? A limited agent, synonymous with dual agency, represents both the buyer and seller in a transaction with written consent. Despite the use of the term representing, The broker's ability to provide services as a traditional buyer's or seller's agent is limited, emphasizing the need for careful consideration, as a limited agent may not serve the best interests of either party well. Internet real estate companies like Redfin and Zillow have fundamentally changed how different types of real estate agents operate. With many self-service tools now available to the public, successful agents have come to provide customers with local expertise, an awareness of the current market, and superior negotiation skills. They should have an understanding of the legalities and paperwork necessary to complete transactions and be continually available to guide customers through the process. You may hear people use the terms real estate agent and realtor interchangeably. That's okay for casual discussion, but there are some minor differences that all real estate professionals should be aware of. Each has a similar workload that includes compiling available property lists, showing homes, and being a general expert concerning the local market. A real estate agent is a licensed individual with the knowledge and expertise necessary to help carry out real estate transactions for their clients. A realtor is simply a real estate agent who maintains active membership in the NAR, National Association of Realtors. With more than 1.6 million members, the NAR holds its members to a higher standard of ethics in return for increased professional prestige. The bottom line? A realtor is an agent who's taken the time and effort to obtain extra accreditation. There is a difference between a real estate agent and a realtor, R. A realtor, R, takes an oath to abide by higher standards. It is dated, and the board president and the now realtor, R, sign the pledge. So let's recap here. What exactly is a real estate broker, and how do their roles differ from those of typical real estate agents? In essence, a real estate broker is a highly accredited professional at a managerial level who not only serves as an agent, but also supervises a team of agents. In many states, licensure is a requirement for all agents, with brokers holding a higher level of licensing. Visualize the broker as a manager, who possesses the added capability to recruit and manage a team of real estate agents. Similar to any agent, brokers can operate on behalf of both buyers and sellers, and they must achieve sales targets annually, in addition to their managerial responsibilities. Among their various responsibilities are preparing a seller's home for listing, presenting properties to potential buyers, negotiating on behalf of either the buyer or seller, handling all necessary paperwork and legal disclosures, offering guidance and support throughout the closing process. Buyer's agent. Distinct from a broker or a general agent, the buyer's agent exclusively represents the buyer's interests in property transactions. Their primary role is to advocate for the buyer rather than being involved in the overall sales process. The buyer's agent is tasked with numerous responsibilities, including compiling a list of potential properties based on buyer preferences, serving as a local market expert, coordinating property walkthroughs, assisting with negotiations and offers. What sets a buyer's agent apart is their focused professional scope compared to a dual agent, reducing conflicts of interest in intricate transactions. Seller's agent. Conversely, the agent for the listing is called the listing agent. The seller's agent is the buyer's agent. The listing agent brings a comprehensive understanding of local markets to assist clients in accurately pricing their property. Additionally, they aid sellers in optimizing their homes for walkthroughs, tours, and open house events, ultimately taking charge of selling the house on behalf of their clients. Dual agent. The final category is the dual agent, encompassing the roles of both a buyer's and seller's agent. Specializing in managing intricate, multi-step real estate transactions, a dual agent serves as a single point of contact throughout the entire process when a client is both selling an old property and buying a new one. Is this a true or false statement? The real estate commissioner can suspend or revoke a license if it is determined that the licensee represented more than one party in a transaction without their knowledge or consent within the past 10 years. The statement is mostly true, but let's break it down accurately based on ARS, paragraph 32, 2153A, 2. ARS Parv 32-2153A-2 authorizes the Arizona Real Estate Commissioner to suspend or revoke a real estate license if the licensee has been guilty of acting for more than one party in a transaction without the knowledge or consent in writing of all parties to the transaction. Clarification. The statute does not specify a 10-year time frame as part of the language itself, but disciplinary actions often include a review of conduct within a reasonable historical window, such as the past 10 years, which may be reflected in ADRI policy or case precedent. The violation is dual agency without written disclosure and consent, a serious breach of fiduciary duty. Final answer. True, the Real Estate Commissioner can suspend or revoke a license for representing more than one party without full knowledge and written consent, under ARS Parv 32-2153A-2. The past 10 years part may reflect investigative scope, not statutory language. There is also express agency, an agency that occurs when a principal and an agent expressly agree to enter into an agency agreement with each other. Express agency contracts can be either oral or written unless the statute of frauds stipulates that it must be in writing. Exclusive agency contract. Power of attorney. Remember that now the seller's agent or listing agent is not obligated to have the seller pay for the buyer's agent's commission. This is all negotiable for the seller. The buyer may be on the hook for the buyer's agent's commission. Make sure your buyers understand how this new law works. Make sure also that the buyer is able to pay if the seller will not. Make sure that the buyer has enough funds to pay for your commission, as well as down payment and closing costs. The lender generally cannot include the buyer's agent's commission in the loan amount. Here's why. 1. Loan-to-value, LTV, ratio limits. Lenders base loan approval on the lower of the purchase price or appraised value. Adding the buyer's agent's commission to the loan would artificially inflate the purchase price, exceeding allowed LTV ratios, a violation of underwriting guidelines. 2. Fannie Mae, Freddie Mac, and FHA VA guidelines. Standard loan programs do not permit financing real estate agent commissions as part of the loan. These costs are considered non-allowable buyer expenses, especially under FHA and VA loans. 3. Commission is a service fee, not a property cost. Lenders finance the property, not professional fees. Commissions to real estate agents are viewed as part of the transaction services, not the value of the property. What is allowed? The seller can pay the buyer's agent commission, as part of seller concessions, if within the allowed limits. The buyer can pay the agent directly with a credit at closing, not financed into the loan.